And then, I have as number 34 is the objection to confirmation of the plan, which may be slightly premature on the docket, so it may be pushed. But let's first take appearances so I know who all is here.
Good morning, Your Honor. Please the court, Craig Gino for the debtor.
May it please the court, Your Honor, Chris Cotton, Assistant U.S. Attorney for the IRS.
Good morning, Your Honor. Karen Rushoff for the United States Trustee.
Good morning, Your Honor. Lee Weber at the probate estate.
Morning, Your Honor. Gary Jewell for JWS Enterprises, Inc.
And then, this also reminds me that we are actually live streaming, on YouTube, on our YouTube channel today. It is no longer part of, VAO's, pilot program, so I don't have to do my usual spiel. But, to the extent any party does object to that, please speak now, or assume that no comments means there is no objection. I believe there's an interested party that wants to tune in, but because of my general rules of virtual appearances, I want to make sure that they are not part of the record and cannot speak. And so, but it is a public forum, and so I want them to be able to tune in if they want to. So there is no objection, so we will continue to live stream. All right, Mr. Gino.
Good morning again, Your Honor. May it please the court, Craig Gino for the debtor. As the court noted, I did not get any objection to the disclosure statement. I did receive from the government an objection to the plan. It may have been, they also did objection to the disclosure statement. But I wanted to bring the court up to speed about some income tax issues in this case that may cause us not to approve the disclosure statement at this point in time. And I'll go through those briefly, but I'll try to be thorough, realizing that I'm about to get out of my bailiwick when I start talking about income tax issues, especially these. The court may recall that Norman Brown, who is the single member of the debtor, LLC, passed away shortly prior to the filing of this case. The case was filed on August 23 of last year. Mr. Brown also was the sole member of a number of other limited liability companies, none of which have made their way into your court or any other bankruptcy court, and probably are not going to. He also was the owner of a straight C corporation called Blaylock and Brown that also has not made it into bankruptcy, at least not yet. And it was the owner, or is the owner, of the landfill that's adjacent to the former assets of E-Box that have now been sold to a third party. So with E-Box being a limited liability entity, it is disregarded for income tax purposes. Mr. Brown's probate estate is pending in state court here. There are a number of claims that have been filed in that case, including one for $10 million or so by the Tennessee Department of Environmental Quality for estimated cleanup cost of the landfill. Mr. Brown has not, prior to the filing of the petition, Mr. Brown in his income tax returns treated E-Box LLC as a disregarded entity, so its income and expenses were included within a schedule attached to his individual income tax returns, as was the case with a number of his other limited liability companies. Many of those companies have tax losses. Whether they can be carried forward or not is an open issue. Don't want to admit or deny a position on that today, but that is an open issue. He did not file income taxes for 2021. He did not file, of course, for 2022. And the tax lawyers and the rest of us are struggling with who, what, where, and when to file for tax year 2022. Because the probate estate was opened in 2022. The case before Your Honor was filed in 2022. None of the other cases have been filed, but they are subsumed, theoretically at least, within the probate estate. We are unsure if E-Box can elect to file its own income tax return as a fiduciary for the stub period in 2022 from August 23 to the end of the year. It might be beneficial for us to do that, but no one seems to know the answer of whether or not, if a decedent sole member of an LLC is a decedent and the LLC is a debtor in possession, can it file a fiduciary return for that stub period? And then maybe the more important question is, if it can file for that stub period, it would probably elect to do the same thing for 2023, when we know that it is going to have some capital gains income taxes from the sale of assets, because many of those assets have been depreciated down to zero, and we had a substantial sales price. We believe those taxes are going to be taxed at capital gains rates, but that's still a substantial amount of money. E-Box also has some obligations for withholding tax, 941 withholding taxes of around $800,000. I understand all those returns have now been filed. We are in a position, maybe early next week, to go to the government and submit what we believe is owed. We're not that far apart based on the government's proof of claim. The debtor also is obligated to file a heavy truck use tax return that we are prepared to file next week. And there is some exposure there, but it's not significant, $10,000 to $15,000, and we still have plenty of money to pay that. Insofar as the other issues are concerned, Your Honor, there are some, as I mentioned, significant tax losses in some of these other entities, but no one is sure whether to file a probate estate tax return for Mr. Brown for the period he was in a probate estate. What's to be done from the time before the probate estate was opened for his taxes, income taxes in 2022, and then what happens after that and in years beyond. We're just simply not in a position today, Your Honor, and the tax lawyers are looking at that. The debtor has not yet hired a tax lawyer. The probate estate has, and we may come back to the court and ask if we can share that tax lawyer. Although there may be some conflicts there, it makes sense not to have 2 or 3 sets of competing tax lawyers. That would be another difficult situation. So that's where we are, Your Honor. There has been, just to bring you up to speed on some other issues, I don't know if you looked at the claims register or not, but there are a number, or the schedules, there are a number of creditors in this case that have that fit within the so-called cabbage loan community. Some people call them merchant cash advances. These are entities that loaned a lot of money to the debtor prior to the filing of the petition. They take back cognitive judgments. They get a judgment form signed up front, and they ding the debtor's checking account or the borrower's checking account every day. And there is a significant amount of debate. The ABI's had a couple of articles on this. There's a presentation in this summer in one of the ABI seminars about whether or not these transactions are factoring, whether they're loans, or whether they're sale of assets. Luckily, in this case, one of the funds that goes around and buys up claims has bought up just about all of those claims, and they've limited, by agreement with us, their claim to either the face amount of the claim, the scheduled amount, or a negotiated amount. Those loans also carry interest rates anywhere from 38 to 86%. So they're cut off interest, they've cut off attorney's fees, they've cut off any issue of owning receivables or anything else, which doesn't really have much to do with the income tax issues or the disclosure statement, because they didn't file an objection to it. And this is a transaction that's just happening in the last week. Documents have been executed, and I suspect I will file a motion to allow those claims as modified and as transferred and sold, and they'll need to file a notice of transfer of claim, with the court, and we'll worry about noticing that out, in due course. But that's kind of where we stand with the disclosure statement, Your Honor. The good thing about this case is there's enough cash available to satisfy what we believe will be all of the administrative priority claims. We anticipate a significant distribution to the unsecured creditors. But standing here today, we don't know not only what the tax exposure is, although it will be pretty significant when you take a $15 million sale and you don't have many deductions because of the depreciation of the assets. And we suspect there will be some tax ramifications, taxes owed from an income standpoint by some entity for 2022. We don't think there's gonna be any for 2021, looking at some preliminary numbers. And we don't know whether or not some of those carry forwards are gonna be, some losses can be carried forward. So I think we're probably looking at 60 days before we get any sort of definitive response from the tax lawyers about where to go and what to do. That impacts exclusivity, and I'll take that up by separate motion because we're gonna run out of that if we don't watch out. So that's where we are. We filed the disclosure statement on time, as well as the plan. No objections to disclosure statement, at least not styled as such. But I don't think we're in a position to approve the disclosure statement because no reasonable creditor could form an investment decision about the plan based on this disclosure statement because of the tax issues that are open.
So what does that leave us? Push everything 60 days and then you would file an amended?
Yes, ma'am, that's what I would anticipate. Actually set a hearing at 60 days out, maybe a status conference, or maybe a new, reset hearing on the disclosure statement. Hopefully, I will be in a position to file an amendment or an amended disclosure statement before then, but I would be surprised if I am. There's a lot to do, and we've got to go through the hiring of the professionals process with the tax lawyers too, between now and then, assuming we agree to share and not do anything else with that.
So I was looking at July 12th. Okay, I'm told that's 56 days. Or we could go to August 2nd.
Wouldn't bother me to go to August 2nd, Your Honor.
Okay.
And I hope we don't need that long, but just in case.
Yeah, and I just don't want you to, I don't like things getting dropped off the calendar, because not that you are somebody that doesn't keep matters moving, but it also is my way to make sure that I know what's going on.
Yes, ma'am.
So August 2nd brings us 11 weeks out. That is a day that it will be a combined calendar, so it might be a busier day, but you have the 10 o'clock docket sometimes runs into 11.
Okay, Your Honor.
So we may contact you the week before and say, let's just set it at 12. Is that okay?
Yes, sure.
That way you're not sitting around potentially. We're usually almost always done, knocking on wood, by 12. Okay, so I will continue, I'll also continue Mr. Cotton's, objection that is on the docket at the moment to August 2nd at 12. And, you have your hands full, Mr. Gino, and hopefully you have some very, very bright accountants.
I do too, Your Honor. We do. I hope we're being creative and we come up with a good solution. We'll see.
Okay,
Thank you, Your Honor.
thank you.
Your Honor, one request, the IRS also has a motion to dismiss in this case, and it's currently set for June 14th. Can we get that set at on the August date as well?
Well, that morning, we'll continue it automatically, but you don't need to appear.
Thank you.
Mr. Gino, that did remind me that there is something else on the court's docket, the stalking horse.
There's a dispute whether the stalking horse gets its breakup fee based on the bid that is submitted or the actual sale price.
And I can't remember when we set that one.
It's on the 14th.
It's on the 14th?
Yes, ma'am.
Okay.
So I'll let you go to August 2nd on the 14th.
Do you wanna push that one to August 2nd, or do you wanna go ahead and, they probably wanna proceed.
Yeah, I'd like to proceed too.
Okay, we'll keep that one on August 14th, is that what you said? I mean,
June 14th.
Strike that. June 14th. All right. That will be a fun little issue.
Yes, ma'am.
All right, well, that should conclude all matters.